Mr. Van der Merwe, thank you very much for your time. Is this the answer that indebted consumers were hoping for?
Well, it no doubt assists. It is helpful in the sense that it is now clear what the extent is of the amounts that can accrue during the time that a debtor is in arrears. You see, this was the issue. In previous years, it was quite unclear what amounts could be added to the defaulting debtors' liabilities, and the court has now made that very clear.
Are you able to give us a practical example of this?
Sure. So the situation is one that Section 103(5) of the National Credit Act says that the amounts that accrue during the time that the debtor is in default cannot in aggregate exceed the unpaid balance at the time of the default. So what that means in practice that is if the debtor owed an amount of, for argument's sake, let's say 500 Rand at the time when they got into default, then any interest and especially legal fees that accrue on that amount cannot exceed that 500 Rand. So that person, that debtor, would then need to repay 1,000 Rand on that 500 Rand arrears amount.
The biggest abuse, of course, Mr. Van der Merwe here, has been the attachment of employees' salaries through Garnishee orders. The question that perhaps many people have in their minds at this hour is, could this spell an end to this kind of practice?
That's not the goal of this specific judgment. The declarator does not go into the issue of emolument attachment order. It doesn't criminalize those or stop it at all. What it does is it sets a cap on the amount that can be collected, whether it be through an emolument attachment order or through any other means.
Whose duty is it to enforce these new rules?
Yeah, that's a good question. One would hope and expect the creditors to now become aware of the judgment and to ensure that they comply with it. If they do not, in those specific circumstances where you have an employer who has an emolument attachment order that is instituted against their employee's salary, then that employer also should look at that situation, should get in contact with the creditor and inform them that they're not willing to deduct amounts above what the court has now specified the limit to be.
Yeah, what about the responsibility of the borrowers themselves? Where do they get information in order to empower themselves about the kind of abuse that they could be facing?
Yes, at this stage, very important that that the borrowers do, that they are informed, debtors are informed of this new ruling, and that's why we're thankful also for programs like these that get the information out there. The easiest way would be for a debtor to get in contact with someone who could assist them from a legal point of view. They, at the very least, should get in contact with their creditors as well. And have these kinds of conversations with the creditor, get the information, in other words, find out what the amount was that they were in default with initially, establish how much they've paid since. And as I say, it's quite clear that as long as they were in default, they're not supposed to pay more than the amount that they were already that was already unpaid at the time of default. Again, the example would be if it was 1,000 Rand that you were in default with, you're not supposed to pay back more than 2,000 Rand.
Is there recourse for those who've been overcharged?
Well, that's another good question. So the Law Clinic, the Stellenbosch University Law Clinic, as well as Summit Financial Partners, we will in the new year approach the court for an application to issue a declaratory order, or not a declaratory, I beg your pardon, but to institute class action and to specifically make an order to describe a specific group or a class of debtors who would fall under the protection of that class action. So we are looking and to get recourse for debtors, and at this stage debtors can stay in contact with proceedings by going to the University of Stellenbosch's Facebook page or even our website.
Fantastic news, and thank you very much for your work, for having approached the courts on behalf of these 10 consumers. That's Stefan van der Merwe. He is the senior attorney at the University of Stellenbosch's Law Clinic.